Good morning again, everybody. Welcome back to the Court of Random Opinion. My name is Lauren Neidigh. This morning, I read really quickly Justin Baldoni's response to Blake Lively's proposed protective order. Now I'm going to run through with you really quickly Justin Baldoni and the Wayfarer party's proposed protective order, which I think is just pretty much the model protective order from the court. But I'm going to go through it with you. So I haven't seen this yet. Actually, I haven't read through it. And we'll do that quickly. Like you guys know, I'm not a lawyer. I'm not a judge or anything like that, so I won't go through a lot of the legal jargon type stuff. But we'll read the document and then I'll get back to work. Thank God for working from home because when I don't have anything in my work queue, I can do whatever I want. um, all right, guys. I'll let a couple more people filter in here before we get started. Hey, Alex, Equality, how's it going? Good to see everybody. Let's see here. I'll pull this up at least. You guys should be able to read that. Hopefully my head's not cutting it off. Let's check this. Yeah, we're good. And also, guys, remember that after my streams, I'm posting these documents on my X account or Twitter, whatever you want to call it. I try to call it X, but I forget sometimes. My username is LethalLauren904, just like it is on YouTube. I know the channel name is changed to Court of Random Opinion, but you can see my name right there under my head right now. There it is. Hopefully it's showing up on your screen, because if not, that's embarrassing. All right. Jason, what's up? Techie Bliss, good morning. All right, let's get started. Whereas all the parties to this action request that this court issue a protective order pursuant to Federal Rule of Civil Procedure 26C to protect the confidentiality of certain non-public and confidential material that will be exchanged pursuant to and during the course of discovery in this case. Whereas the parties through counsel agree to the following terms. Okay. Whereas the parties acknowledge that this protective order does not confer blanket protections on all disclosures or responses to discovery, and that the protection it affords only extends to limited information or items that are entitled under the applicable legal principles to confidential treatment. Okay. Whereas the parties further acknowledge that this protective order does not create entitlement to file confidential information under seal, and whereas in light of these acknowledgments, and based on the representations of the parties that discovery in this case will involve confidential documents or information, the public disclosure of which will cause harm to the producing person and or third party to whom a duty of confidentiality is owed, and to protect against injury caused by dissemination of confidential documents and information. This court finds good cause for issuance of an appropriately tailored confidentiality order governing the pretrial phase of this action. It is hereby ordered that any person subject to this protective order, including without limitation the parties to this action, their representatives, agents, experts, and consultants, all third parties providing discovery in this action, and all other interested persons with actual or constructive notice of this protective order shall adhere to the following terms. So their order here is just probably going to be less restrictive. Like there's going to be less that they're saying needs to be kept confidential or needs to be kept out of the public eye. Obviously, with Blake's, we went over the changes from the model protective order to Blake's proposed protective order this morning a little bit. If you didn't see that stream, it was only about 15 minutes long, so you can watch that if you want. We went through the changes that she made, including adding a lot of items for high-profile individuals, aka Taylor Swift. So, you know. All right, now here are the terms. 1. Any person subject to this protective order who receives from any other person subject to this protective order any discovery material that is designated as confidential pursuant to the terms of this protective order shall not disclose such confidential material to anyone else except as expressly permitted hereunder. Pretty standard. Hey, Erica, what's going on? Hi, Crow. Right. The person producing any given discovery material may designate as confidential only such portion of such material the public disclosure of which is either restricted by law or will cause harm to the business, commercial, financial, or personal interests of the producing person and or a third party to whom a duty of confidentiality is owed. And that consists of previously non-disclosed financial information, previously non-disclosed material relating to ownership or control of any non-public company, previously non-disclosed business plans, product development information, or marketing plans, any information of a personal or intimate nature regarding any individual or any other category of information hereinafter given confidential status by the court. With respect to the confidential portion of any discovery material other than deposition transcripts and exhibits, the producing person or that person's counsel may designate such portion as confidential by A, stamping or otherwise clearly marking it as confidential, the protected portion, in a manner that will not interfere with legibility or audibility, and B, producing for future public use another copy of said discovery material with the confidential information redacted. So we'll probably see some of that then, like some stuff that's going to get released with names blacked out or phone numbers. Well, phone numbers, social security numbers, anything like that should always be blacked out. But so it means that we might not necessarily not get to see something in its entirety, but they will, block some portions out. Though I'm sure there are some things that we're not going to be able to see, as with any court case. The public. Okay, let's see. And I was reading this here. So they have to mark it confidential in a manner that won't interfere with legibility or audibility. And so I'm thinking, like, how would it interfere with audibility? If it's like a sound clip or something, I guess you'd have to like shout over it, like confidential. You know what I mean? It's too early for that. Anyways, I'm gonna pretend that didn't happen. With respect to deposition transcripts, a producing person or that person's counsel may designate such portion as confidential either by A, indicating on the record during the deposition that a question calls for confidential information, in which case the reporter will bind the transcript of the designated testimony, consisting of question and answer, in a separate volume and mark it as confidential information governed by protective order. Well, that's a mouthful. SIGPO. There we go. Or B, notifying the reporter and all counsel of record in writing within 30 days after a deposition has concluded of the specific pages and lines of the transcripts and or specific exhibits that are to be designated confidential, in which case all counsel receiving the transcript will be responsible for marking the copies of the designated transcript or exhibit in their possession or under their control as directed by the producing person or that person's counsel by the reporter. Okay. So again, it's like with the deposition transcripts and stuff like that, some of it may be blocked out. During the 30-day period following the conclusion of a deposition, the entire transcript will be treated as if it had been designated confidential. Okay. If at any time prior to the trial of this action, a producing person realizes that some portions of discovery material that she, he, or it had previously produced without limitation should be designated as confidential, she, he, or it may so designate by so apprising all prior recipients of the discovery material in writing, and such designated portions of the discovery material will be deemed to be and treated as confidential. Okay. No person subject to this protective order, other than the producing person, shall disclose any of the discovery material designated by the producing person as confidential to any other person whomsoever, except to the parties to the action, their insurers, and counsel to their insurers. Counsel retained specifically for this action, including paralegals, clerical staff, etc. Outside vendors or service providers that counsel hire and assign to the matter, including computer service personnel performing duties in relation to a computerized litigation system. Any mediator or arbitrator that the parties engage in this matter or that this court appoints, provided such person has first executed an NDA, as to any document, its author, its addressee, and any other person indicated on the face of the document, of course. Any witness who counsel for a party in good faith believes may be called to testify at trial or deposition, provided they first executed an NDA. Any person retained by a party to serve as an expert witness or otherwise provide specialized advice to counsel in connection with this action, provided such person has first executed the NDA. Stenographers engaged to transcribe depositions conducted in this action, and this court, including any appellate court, and the court reporters and support personnel. So when we went over Blake's this morning, the edits that they had made to the model protective order, they had added something here about the NDA where they're saying if somebody refuses to sign the NDA, they have to go on record stating as such. So they were taking an extra step there. They had to go on record stating as such, and then also would be subject to sanctions if they were to disclose any information. It's 7 a.m. California time. Elle, you got to be a lawyer. I am definitely not a lawyer, but hey, from Florida. How's it going? All right. Prior to any disclosure of any confidential discovery material to any person referred to in subparagraphs 6D, F, or G, such person shall be provided by counsel with a copy of this protective order and shall sign an NDA in the form annexed as an exhibit. Said counsel shall retain each signed NDA, hold it in escrow, and produce it to opposing counsel either prior to such person being permitted to testify at deposition or trial, or at the conclusion of the case, whichever comes first. Any party who objects to any designation of confidentiality may at any time prior to the trial serve upon counsel for the designating person a written notice stating the grounds of the objection. If the parties cannot reach agreement promptly, which these guys don't seem to reach agreement very often, counsel for all parties will address their dispute to this court in accordance with paragraph 1C of this court's individual practices in civil cases. Any party who requests additional limits on disclosure, such as attorney's eyes only in extraordinary circumstances, may at any time prior to the trial of this action serve upon counsel for the receiving party a written notice stating with particularity the grounds for the request. If the parties cannot reach agreement promptly, counsel for all parties will address their dispute to this court in accordance with paragraph 1C. A party may be requested to produce discovery material that is subject to contractual or other obligations of confidentiality owed to a third party. Within 2 business days of receiving the request, the receiving party subject to such obligation shall inform the third party of the request, and that the third party may seek a protective order or other relief from this court. If neither the third party nor the receiving party seeks a protective order or other relief from this court within 21 days, the receiving party shall produce the information responsive to the discovery request, but may affix the appropriate controlling designation. Okay. Recipients of confidential material may use such material solely for the prosecution and defense of this action and any appeals, and specifically may not use confidential information for any business, commercial, or competitive purpose. Nothing contained in this protective order, however, will affect or restrict the rights of any person with respect to its own documents or information produced in this action. Nor does anything contained in this protective order limit or restrict the rights of any person to use or disclose information or material obtained independently from and not through or pursuant to the federal rules of civil procedure. Hey, P, what's up? Linda says, Laura needs to hit 10K today. I don't know. We're getting closer. I don't know about today. That might be a little ambitious. All right. Nothing in this protective order will prevent any person subject to it from producing any confidential discovery material in its possession in response to a lawful subpoena or other compulsory process, or if required to produce by law or by any government agency having jurisdiction, provided, however, that such person receiving a request will provide written notice to the producing person before disclosure, and as soon as reasonably possible, and if permitted by the time allowed under the request, at least 10 days before any disclosure. Upon receiving such notice, the producing person will have the right to oppose compliance with the subpoena, other compulsory process, or other legal notice if the producing person deems it appropriate to do so. All persons seeking to file redacted documents or documents under seal with the court shall follow Rule 2H. No person may file with the court redacted documents or documents under seal without first seeking leave to file such papers. All persons producing confidential material are deemed to be on notice that the Second Circuit puts limitations on the documents or information that may be filed in redacted form or under seal, and that the court retains discretion not to afford confidential treatment to any confidential discovery material submitted to the court or presented in connection with any motion, application, or proceeding that may result in an order and or decision by the court, unless it is able to make the specific findings required by law in order to retain the confidential nature of such material. Let's look at that sentence again because it was like 1,000 pages long. All right. All persons producing confidential material, they're on notice that the Second Circuit puts limitations on the documents that can be filed in redacted form or under seal. Okay. The court retains discretion not to afford confidential treatment to any confidential discovery material. Huh. Okay. Notwithstanding its designation, there is no presumption that confidential material will be filed with the court under seal. The parties will use their best efforts to minimize such sealing. So they're going to try to make this as like the least restrictive possible, I guess. All persons are hereby placed on notice that the court is unlikely to seal or otherwise afford confidential treatment to any discovery material introduced in evidence at trial, or supporting or refuting any motion for summary judgment, even if such material has previously been sealed or designated as confidential. Any party filing a motion or any other papers with the court under seal shall also publicly file a redacted copy of the same via the ECF. That redacts only the confidential material itself, so it doesn't redact the text that isn't considered confidential material. Okay. Each person who has access to discovery material that has been designated as confidential shall take all due precautions to prevent the unauthorized or inadvertent disclosure of such material. Hey, Steph, what's up? Reg, you changed your name. All right. All personally identifying information, like social security numbers, financial account numbers, passwords, and information that may be used for identity theft, exchange and discovery shall be maintained by the persons who receive such information and are bound by this order in a manner that's secure and confidential. So I guess they can't go around giving out people's social security numbers and passwords. In the event that the person receiving PII experiences a data breach, they should immediately notify the producing person of the same and cooperate with the producing person to address and remedy the breach. Again, that seems pretty standard. Okay. Nothing in this document precludes that person from asserting legal claims or constitutes a waiver of legal rights. Okay. This protective order shall survive the termination of the litigation. Within 30 days of the final disposition of this action, all discovery material designated as confidential and all copies thereof shall be promptly returned to the producing person or, upon permission of the producing person, destroyed. All persons subject to this protective order acknowledge that willful violation will subject them to punishment for contempt of court. Okay. So that's pretty standard, guys. And here's the NDA, which I think we all know what an NDA is. So, all right. Like I said, that was not super exciting, but I'm going to go over pretty much everything that comes up unless it's like extremely mundane. At that point, I will like post it on my YouTube page under a post, or I'll post it on X. Let me show you where I posted this document. Hold on. Gotta share that again. Okay. So that's me at Lethal Lauren 904. And then I put the documents here. Justin Baldoni proposed proposed protective order. And then I posted the document right here. Also, I have a couple others. I put the response to Blake's proposed protective order here. And then as you can see, I have some more documents that I've added. So as documents are coming out and I download them off of Pacer and or Court Listener, I'm going to put them there just so you can easily access them all in one place. I know not everyone has time to watch a YouTube video, but I do appreciate everyone who does take the time out of their day to listen. Even though, like I said, I'm not a lawyer. That's why this is a court of random opinion. So, all right, everybody. I appreciate you, and I will see you later on today, probably. Bye. Oh, and yes, please hit the like button. Thanks.